The appeal is dismissed. No cost.
I'm a bench.
My lord, may I
Yes.
seek indulgence to mention item number 3? May this
Number 3.
Yes, my lord.
Yes, what happened?
I take the consent from the other parties and may this matter be come up on Friday.
Part 1, item number 3.
Part 2, item number part 3.
2. I think we're already fixed it for Thursday. Isn't it? No? Item number 3. Yes. When do you want it?
Friday, this coming Friday.
Not possible. We'll be leaving for the airport. So make it in the next week.
If possible, Thursday, my lord, if they're ready.
Friday.
Friday, they do it.
Thursday. Next week, my lord.
Part 3 item.
On the submission made by the learned counsels for both the parties, list in the next week.
Obliged, my lord.
My lord, part 2, item number 4.
Item number 4, what?
In the last court, I am submitting to take up the matter after the outcomes of review petition number 2 of 2025. And the review petition number 2 of 2025 has not yet come out the outcomes, and may this matter be
Okay.
taken up after the.
Yes, not objected on the submission made by Ms. Jacinta Zothanmoy, learned counsel for the petitioner. List the matter after 2 weeks, 3 weeks.
3 weeks after.
Okay. Yes, Mr. Samuel Vanlashiata Chanke, learned counsel for respondent number 2 and 3 is present along with Ms. Baby so-and-so, appearing on behalf of Ms. Rim Sangpui, learned CGC for respondent number 1. Yes.
Mission item 2.
Question of mental ability of read petition, madam. I don't think it is not maintainable because we are against the order of the district collector.
Anyways, let's see. Yes.
My lord, we have just received a
No,
copy.
it is not. It is different. Item 2.
Item number 2.
Yes, madam. Item number 7 to 10 also they raised the mental ability. In that case, we file reply rejoinder. So that is.
So in item number 2, are you going to file your rejoinder?
My lord, it is not required, my lord. If court allowed, then I'll file.
Okay,
rejoinder.
so pleadings complete can be listed for admission hearing.
Yes, my lord, because the
Yes.
readable is pending,
Yes.
my lord, is
Mr. Sanjay Kumar Medi, learned counsel for the, now here you are for
I'm the
whom?
read petitioner. Read petitioner, my lord.
This is item number 2, isn't it? Yes, learned counsel for the petitioner is present along with Miss
Ruler Watfili for respondent
Ruth.
1 to 7.
Lalrod Feli, learned counsel for respondents number 1 to 7.
8 and 9 is the same.
Okay, instead of along with, make it is present, then Ms. Lalroti, learned counsel for respondent number 1 and 2 is present along with Mrs. Linda L. Fumble, learned PP for the state respondents. It is submitted. by both the parties that pleadings are complete. In view of the above, list the matter for admission hearing on,
2nd of September, my lord.
okay, 2nd, 9/20/25.
Well, the item number, my lord,
This is two, item number 3.
no, 3.
So, well, let's do item number 3 first. Yes. You are
Item
there in
3.
item number 3? No. Call out, huh?
May it please your lordship?
Call out.
An additional affidavit was filed by the petitioners, and in the last, when the matter was last listed, I was given the permission to get instructions regarding whether an affidavit will be filed or not to the additional affidavit filed by the petitioners. Accordingly, your lordship, I have been given instructions that 3 weeks time may be granted.
You're going to file a counter?
Yes,
to
Your
the
Lordship.
additional
Yes,
affidavit
your
filed?
lordship.
Yes, Mr.
Carolyn.
K. Roland, learned counsel for the petitioner is present, along with Lal Nundui, learned government advocate for the state respondents. Stop. The learned government advocate has prayed for time to file the counter affidavit to the additional affidavit filed by the petitioner. In view of the above, list the matter after 3 weeks.
3 weeks, your lordship.
They may be fixed.
You want a date? 3 weeks on, give a
First
date.
or 22nd.
Your lordship, I cannot guarantee that I'll be getting the paras comments on the
Make
22nd.
an attempt, make it attempt. After 3 weeks on, 3 weeks, give me a date.
21st, 22nd or 21st.
22nd, your lordship.
On 22nd September, October, no,
August.
August. 22nd August 2025, yes.
Much apologies.
Item 4.
I seek lordship's indulgence in making a mention on behalf of Mr. Elish Lenshima. He has some personal difficulties, so if this matter may be taken up after a week.
Ms. Ruth Lalwatfedi, learned counsel appearing on behalf of a senior, Mr. L.H. Lianshima, learned senior counsel for the petitioner is present, along with Mrs. Linda L. Fumble, learned additional AG, full stop. The learned counsel for the petitioner has prayed for adjournment of the matter, which is not objected by the learned additional AG. In view of the above, list the matter after 1 week. Yes.
Item 5 and 6.
Yes, item 5, no? No, item number 5, my lord, today I'm going to file affidavit, my lord.
Okay. You're the appearing for respondents number 3 to 7,
Yes,
is it?
railway.
Union of India.
Railway, I'm for railway. 6.
You're for, okay, 6. And Ms. Zairam Sangpu is for?
Respondent number 3, 4, and 7.
3,
3,
4,
4,
and
5, and 7.
Okay. Mr.
Dalton Moya.
Dalton Moya, learned, is your name here?
Yes.
Laltan Moya, learned counsel for the petitioner is present. Full stop. Then Mr. S.K. Medi, learned counsel for respondent number 6, has prayed for further time.
Well, today I'm filing.
Okay, submits that he will be filing the counter affidavit during the course of the day. Full stop. Then Ms. Baby so-and-so appears on behalf of her senior, Ms. Zairam Sangpui, learned CGC, for respondents number 3, 4, 5, and 7. The learned, who has also prayed for time. Have you filed?
Not my lord.
You're going to pray for time?
Yes, my lord.
Who has prayed for further time to file the counter affidavit? Full stop. Then, have you filed?
I'm
Okay. Ms. So-and-so, learned government advocate, has also, learned government for respondents number? 1 and 2, has also prayed for further time to file their counter affidavit. Stop. In view of the above, list the matter.
2nd of September.
Okay, on the 2nd September 9, 2025. Yes.
Six.
Item 7.
Six.
No, item number 5. Okay, now item number 6. Yes. What is this thing here, Zaim Sangpui?
Lordship, I'm appearing on behalf of respondent number 4 to 7. May I seek another 2 weeks' time for filing affidavit in opposition?
How long are you going to take, isn't it? Vanessa?
Similar
you filed?
prayer, Your Lordship. I'm representing the respondent number 1, 2, and 3.
Mr. H. Zodin Sanga, learned counsel for the petitioner is present. No, Mr. Jonathan El Silo, learned counsel for the petitioner is present, along with Miss Baby so-and-so, appearing on behalf of Miss Zairem Sangpui, learned CGC, for respondents number 4 to 7, and Miss Vani Siami, learned government advocate for respondents number 1 to 3. The learned counsels for the respondents have prayed for time to file their counter affidavit. In view of the above, list on same date, previous date. Okay. Yes.
Item 7.
Yes.
7 to 10, my lord, during the course of the day, I'm going to file rejoinder, my lord. Already served the copy.
Rejoinder.
Yes, my lord.
Okay, Mr. S.K. Medi, learned counsel for the petitioner is present, along with Miss Ruthi so-and-so, Ruth so-and-so, learned counsel appearing on behalf of her senior, Mr. Elish Julian Shima, learned senior counsel for the private respondents, and Mr. Samuel Valashiata Changte, learned additional AG for the state respondents. The learned counsel for the petitioner submits that he will be filing his rejoinder affidavit during the course of the day. In view of the above, list the matter on
Meanwhile, my lord, the state will also be filing the affidavit in opposition.
today,
Not today, my lord, within 2 weeks, my lord. I've just received the advance
during
copy.
the course of the day,
Same prayer, my lord.
while the learned additional AG submits that they will be filing their counter affidavit. No, submits that he may be given time to file the counter affidavit. In view of the above, list on
Second
same
of-
date,
sec-
2nd,
second
9,
of-
2020.
Item number 7 to, my lord. 7, 7 to 10, my lord, same, my lord. 7, 8, and
Item 8.
8 is the same, my lord.
So you will be filing your
Yes, during the course of the day.
rejoinder.
Yes, already
Okay.
filed,
Same order is present and submits that he will be filing his, because it's not here in the file, isn't it?
yes, my lord, I'm filing, going to file.
And then what about you?
Similar prayer, my lord.
What is state? Okay, same order. What about you have filed a counter,
Yes, my
isn't it?
Private
Same order
respondent.
as the previous order. Yes.
Item 9.
9 is the same, my lord.
Same?
Same,
Okay, 9, same order.
and 10 also same, my lord.
9 and 10,
Same.
same order. So you have filed your rejoinder affidavit?
I have the soft copy, my lord, the government has
Okay,
done private one, and I'm going to file. File, my lord.
Item 11 and 12.
Your Lordship, to RFA, it was in the previous court date, this instant IA was not listed. IA number 36 was not listed. That's why it has come up this time. So my learned friend has not objected the.
Lordship, in this respect, IA number 36.
Wait, where's the IA? There's no IA here. This is RFA 17 and
RFS
RFA 6.
RFS 17, 2025, there is no IAA. And in IA number
IA
36 of
36,
2025
yes.
is arising out of RFA number 6 of 2025.
What is the IA about?
It's a operation of stay, application for stay. of
So
judgment
now
and order.
let's look at item number 11 first, isn't it? Now, item 11 and 12 have been clubbed together
Together, yes, Your Lordship.
because the parties are the same? Okay.
Yes, Your Lordship.
Maybe
With
the
common
landed
justice.
property is different, is it?
No,
The
no, no.
dispute.
It's a heirship, and we challenge the heirship certificate and successor certificate, and it's a common order.
Common order? Okay, fine. So now here in item number 11, trial court records have arrived. Paper
believe it
book
has
is
arrived.
prepared. Paper book, is it ready?
Not yet ready.
Not yet ready. Then we'll wait for some more time.
Lordship, IA number 17, RFA number 70 of 2025 is regarding the challenging the heirship certificate. And stay order was issued,
Granted.
and we have no objection in this
yes, yes,
respect.
yes.
And in respect to item number 12,
Six,
there is IA number 36 of 2025. I would like to file my affidavit.
Okay, so let's do, pass an order for item number 11 first. Okay. Mr. K. Rowland, learned counsel for the appellant is present along with Ms. Jacinta, learned counsel for the sole respondent. Is it? Full stop.
Yes, ma'am.
It is submitted that though LCR is received, paper book is not ready yet. In view of the above, the registry to prepare the paper book at the expense of the appellant. Okay, this is 11. Now, in RFA 6, there's an IA. Okay, now, Mr. K. Rowland, learned counsel for the applicant is present along with Ms. Jacinta, so and so. The learned counsel for the respondent has prayed for time to file their written objection to the IA. In view of the above, list after,
The order dated 3/3/2025 has stayed the operation of the interim judgment and order 27/2/25. It may be extended.
so what is the IA about? If operation is already stayed, now in the RFA 17, you just add, meanwhile, interim order passed earlier shall continue till the next date of listing. Okay. Now, in RFA 6,
It's
What is
also the
RFA
similar-
6?
It's similar.
similar means what? Airship certificate?
Heirship-
Succession certificate.
Succession certificate.
Succession. While in RFA 17, it's an airship.
Yes,
Yes.
yes, my lord.
So succession certificate is regarding some money in the bank,
Yes, my
most
lord.
probably.
Yes, my lord.
Okay. So now, in the IA is prayer for stay of the release of the money to the, whatever, the respondent, most probably. Is it?
Yes, sir.
Okay, so we'll give you, how much time? 3 weeks' time, both? Okay, list after 3 weeks. Now, the IA is connected with the RFA 6, so no need to pass an order for RFA 6. Okay, yes.
Item 13.
Lordship, this I is for disbursement of the interest portion in Lordship, which was incurred from the deposited amount of rupees 12,76,500 rupees in Lordship.
What will be the interest amount?
Lordship, I'm not sure that how much is with
So
the
it's been
registry.
deposited, the interest, or what? What's happened to the main case? The
Main
matter
case,
fee?
Your Lordship, I have already take out the money from the registry. I have annexed page 52, Your Lordship.
The
check.
main case has been disposed of.
Main case is already disposed of, and the insurance
is the
company
order?
had order. I may take Lordship to page 49. of,
Okay. Yes, so, okay, this is my
this is,
judgment.
yes, this is
Okay.
the IA. And may I read
It's also
Lordship's again?
required to the remaining balance also with the stipulated interest within 3 months from the date. So now, the awarded balance amount of, from the award of, so the balance amount is 12 lakh something?
12 lakhs something. Lordship, Mary Lordship, this the at the time of filing this MAC appeal, the insurance company had deposited 50% of the awarded amount.
Yes, yes.
So that was in the registry, and the main MAC appeal was rejected, and I have filed the IA for taking out of that money, and the order is at page 49. Your Lordship had passed the effective order, and here, since I paid for the applicable interest from the deposited amount, which is 12,76,500 rupees, but in the order, Your Lordship, in the effective order, that interest portion was silent. So I have approached the registry, and since there is no specific order from this honorable court, so I was,
No, the insurance is also to the remaining balance from the awarded amount of so and so with the stipulated interest amount.
Lordship, yes.
So interest amount,
Lordship, yes, interest is still with the registry. They have given me only the deposited amount.
why? The
Lordship,
order says with the stipulated interest amount, interest also has to be given.
interest has to be given, Your Lordship, but
Okay,
Also,
maybe the paragraph, the first paragraph,
yes, yes, Your
which has
Lordship.
been dismissed, but finds the award 50% of the awarded amounts are deposited in the registry on so and so should be disbursed.
Should be disbursed to the appellant by the registry after due verification. In that portion, Your Lordship, the interest amount was silent. That is the reason why
But interest amount is deposited?
it deposited, Your Lordship.
Okay.
It's with the
Yes,
registry, Your Lordship.
yes. I think there's no need to file any written objection to this.
Yes, Your Lordship, we
isn't
have
it?
no further objection or
Yes.
submission.
Heard Mr. Johnny L. Tauchung, learned counsel for the applicant, along with Miss
Sarah Lal Vensangi.
Sarah Lalvensangi, learned counsel for the respondent insurance company. Full stop. This is an application filed under section 151 CPC for disbursement of the interest from the deposited 50% awarded amount of rupees 12,76,500, which was deposited in the registry on 22/03/2024. Full stop. It is submitted by the learned counsel that since there was no specific direction given regarding the disbursement of the rupees 12,76,500 in the judgment of this court dated, what's the date?
It is, Lordship.
Dated 03/07/2025,
Lordship, yes.
in IA within brackets civil close bracket /94/2025. The learned counsel submits that the interest to the deposited amount may also be allowed to be dispersed to the applicant/claimant. Ms. So-and-so, learned counsel for the insurance company, submits that they have no objection to the instant IA. In view of the above, the registry to disperse the interest amount arising out of the awarded amount of rupees 12,76,500, which was deposited in the registry on 22/03/2024 to the applicant claimant after due verification. Yes. Accordingly, IA number 120/2025 stands allowed and disposed of. Yes.
Much obliged, Lordship.
Item 14.
My lord, this matter is listed for the first time, and IA is about a continuation of 169 days. And
In what?
and-
Condonation, in what? In filing what?
in filing a regular first appeal on for order dated 14/11/2024
In?
in Court of the Civil Judge Senior Division 1 in Monisud, number 46 of 2020.
Regarding a money suit?
Yes.
What is the amount of the money suit?
The amount
Involved?
15 lakhs with
Okay.
10% interest.
So you're unhappy with that? Heard, Miss?
Lerumbrati Rentle.
Lerumbrati
Lerumbrati Rentle.
Rentle, learned counsel for the applicant, who has filed the instant application under Section 5 of the Limitation Act, 1963, for condonation of 169 days delay in filing a regular first appeal against the order dated 14/11/2024, passed by the Court of Civil Judge within brackets Senior Division -1, Aizol in money suit number 46 of 2020. Full stop. Issue notice to the opposite party / respondents through registered post with AD within 3 days, returnable by 3 weeks. List after 3 weeks.
Obliged.
Part 2, item 1.
Yes.
Yes, Your Lordship.
The government is not here?
She's here in the morning.
She's here in the morning.
I think she's ready.
Okay. Yes. What is the matter about?
This is, Your Lordship, a promotion of Havildars to sub-inspector in the arm branch of Mizoram Police. May I kindly bring you to page number 50 of my petition. As per Rule 3972B of Mizoram Police Manual 2005, Departmental Promotion Committee was constituted by notification dated 6/11/2023. And in the next page, a practical test board was also constituted by notification dated 5/12/2023. That is the notification for practical test board. And on 6/12/2023, on page number 52, all commandants and superintendent of police, security, and principal police training school hands-on were requested to submit list of willing candidates to appear in the departmental test for promotion of Havildar to sub-inspector branch, which was tentatively scheduled to be held in 8 January 2024. And on page number 54, a corrigendum was issued in partial modification to the headquarters of the previous order on 6/12/2023. That date for practical test, departmental test was
Okay, no, 5th December, this is Departmental Promotion
yes,
Committee.
departmental, yes.
The previous one was Departmental Promotion Committee. First, 6th November, a departmental promotion committee was constituted, isn't it?
Yes,
To
6
consider-
November, 6 November.
Oh, 6th November.
Then on 5th
Chairman, then
December,
on 5th December, what happened?
on the 5th December, practical test board was constituted.
Okay, this is practical test board.
Yes, practical test board. Departmental promotion
Okay.
committee is on 6/11. Then on 5/12, practical test board was constituted. And on 6th December 2023, it was notified to all commandants and superintendent of police, and that the departmental test for promotion was tentatively scheduled to be held in 8 January 2024.
Okay.
Then a corrigendum was issued, which was the departmental test for promotion, which was scheduled to be held from 8 to 13 January 2024, was postponed on 29 January 2024 to 2nd February 2024.
Okay.
Then on 8 January, in the next page, number 55, officers listed in the tables were detailed for examiners in the departmental test of Havildar for promotion to the rank of SIAB to be held at Hart Battalion MAP headquarters. Yes. Then another notification was issued by the was issued on 8 January 2024. It is notified that this is a routine for practical tests and written tests for departmental tests for promotion. Yes. Then, since there is no details to be laid out in the police manual, the respondent authorities used to issue standing orders for this departmental promotion. Herein also standing order was issued on 22nd November 2021.
What is the standing order?
This standing order is for, may I
Yes,
read out? Yes.
page 57.
Yes, P57, standing order.
This is before 2021, previous.
yes. Promotion of various ranks in Mizoram Police is governed by the Mizoram Police Manual 2005. Accordingly, promotion to the rank of SIAB has been done in conformity with Rule 363 and 397 of Mizoram Police Manual 2005. However, the said provision do not provide details as such standing orders were issued from time to time in supersession of the previous order dated 23/8/2016. Standing order is made as below for the purpose of assessing the performances of the Havildars in the departmental test for promotion to a sub-inspector branch. That is why this standing order is
Okay, because
issued.
the detail is not there in the Mizoram Police Manual.
Yes,
is it?
yes. Then this is applicable in the present case. The standing order is. Then another guideline was also issued for assessment of candidates' performance in the departmental test for promotion. This guideline is issued in 23/8/2022. A standing order as well as guidelines were issued for the,
Page 59.
yes, page 59 and 60. Then, after the departmental test was finished, over, then the IGP headquarters and chairman practical test board had issued office order and released those who are participating in the departmental test. By office order dated 5/2/2024. to join their respective unit. Yes.
Page,
Number 61.
page 61. Okay. So, 2 persons, is it?
Yes.
No, how many
No.
people?
221 persons.
The following Havidas have been promoted. Okay, so following will be next page,
Yes.
page 62.
Yes.
Okay.
Then may I kindly bring you to page number 68. This is the minute of the Departmental Promotion Committee.
68.
Yes. In the last para of that page, after careful deliberation, the Departmental Promotion Committee drawn select lists and recommend the following Havildars for promotion to the post of Sub-Inspector at level 07 in the pay matrix such and such from departmental test conducted on 29/1/2024 to 5/2/2024. The following are the list of select lists. And in page number 69, the Departmental Promotion Committee further drawn reserve select list. There are 7 persons in the reserve select list. Then,
Page 70.
yes, page number 70 is a note sheet.
So where's the reserve list?
The reserve list in page number 69, reserve select list.
Okay.
Then page number 70 is only a note sheet with regard to Departmental Promotion Committee.
So why have you enclosed this?
Yes.
Any importance? Any
It is,
significance?
it is done with approval of the DGP and of the DGP.
Okay.
Yes. Then on page number 72, this is an order for promotion. On 29/2/2024, in pursuance of the recommendation of the Departmental Promotion Committee held on 22/2/2024, the following Havildars are hereby promoted to the rank of Sub-Inspector of Police, Branch, on selection quota in order of merit in the level of 07, such and such of the pay matrix plus other allowance admissible under the rules from time to time imposed to the places as shown against their names with immediate effect. Then the following 18 Havildars were promoted to Sub-Inspector in the branch of Mizoram Police by this office order. And
Yes.
page number 74 is the overall result departmental test of promotion committee for promotion to the rank of Sub-Inspector of Police in order of merit that is obtained through RTI application. Then after the result was declared and promotion was done, those who participated in the departmental test for promotion had submitted a representation to the Mizoram Armed Police
What is
Association.
this Makpe Kerem Tilo?
This is obtained by applied by a person who is but those who are not willing to disclose their marks.
Okay. So each individual is asked whether they are willing to disclose their marks, is
Yes,
it?
yes, yes.
So they did not want.
Yes.
Okay. So where are the petitioners here?
The petitioners,
Are in serial number what?
there are 123 petitioners, but
How many persons were promoted?
18,
18.
yes.
So it's not the top 18? Top 18 were promoted or some people in between?
Yes,
What?
top 18 are promoted.
Top 18 are
Yes,
promoted
yes,
from this marks.
yes, these marks, yes.
You're unhappy with that
Yes, yeah, we are unhappy with the result.
marking?
Yes, markings.
Okay. You appear in with serial lower C, but you don't know. 120, it's a huge amount. Okay.
Yes, yes.
Yes.
Then, after that, the representation was submitted to the president, the Mizoram Armed Police Association, MAPA, in short, by the petitioners. Then a copy of that representation is at page number 83. Then this representation was forwarded to the higher authority by the president and general secretary of the MAPA, but no action was taken. Then the main grounds for challenging the result and the promotion of the is that on page number para 16 of my petition. May I read out?
Para 16.
Yes. That pilal nun eh.
Wait. Let's wait for something. Para 16 starts with P. Lal Nunengi, is it?
Yes, yes. Page
Yes.
number 37. That pilal nun eh, resident of Chingaveng Aizol had submitted an application dated 21/3/2024 under the Right to Information Act 2005 for obtaining Xerox copy of the original marks in respect of the selection of the promotion of Havildar to the rank of SIAB held during 29/1/2024 to 5/2/2024. The SPIO had furnished RTI reply on 29/4/2024 and unexpectedly informed her that there was no Xerox copy of original table mark to be furnished to her, as the same had not been submitted to the PHQ by the practical test board. This reply against the RTI application had clearly revealed the selection was carried out with unfairness and partiality. It had also indicated that transparency was not maintained in respect of the practical test. Every participant should have a fair chance to thrive based on their merit, not on discriminatory factors. A selection process presided over by the internal motive of the unfairness, discrimination, and obscurity. The same suffers from several errors and is unsustainable to the settled principles of law. Then that RTI reply is in page number 86 of my petition.
86.
Yes. It is written in Mizo language. RTI mga
Wait. That's, you wait
Yes.
for some time. Let me, page
Yes.
86.
86, yes.
In translated copy is 87.
Yes, 87. In Mizo language. Original table mark Xerox copy le.
So read page 87
Yes.
in this translation.
The answer to the information you have seek through RTI 21/3/2024 is as under. Xerox copy of the original mark in Havildar Sub-Inspector mark overall. Xerox copy of the original mark has not been submitted by the practical test board in PHQ, therefore there is nothing to be furnished. The result mark overall of Havildar Sub-Inspector involve another person's interested third party. As such, the permission and consent of the third party involved have to be obtained first Since they refused to enclosure of their marks, it has been kept in blank. This is noted at the remarks column. Result marks are attached in the annexure. That the result which they have given me is at page number 74.
Which you've already shown me.
Yes.
Huh.
Uh,
This was given, no?
yes.
So here, Mark Pekrem Tilao, she's unhappy with this?
Yes.
Oh, okay.
Because what we seek through RTI application is original table mark means while doing outdoor practical tests, the persons who are appointed as a member of practical test board had given their marks in a handwritten by using a ball pen or a pen. Then that table mark was seeked through the RTI. But that is not available in the PHQ since they have stated that the practical test board did not submitted the that original table marks to the PHQ. In this regard, with regard to this honorable court provide its order on 12/3/2025.
Where? In this case?
In this case, yes. The Honorable Mr. Justice Michael Zotan Kuma on 12/3/2025. On the prayer of, in the second para, Ms. Vanessa Milanen government advocate shall produce the official records showing the marks of the petitioners and the private respondents. And that is the order of the court on 12/3/2025.
Yes.
Yes.
So what happened to this?
In the next date of in the next date, 23/4/2025. List the matter again on 5th May 2025. In the meantime, the learned government advocate Vanessa shall go through the relevant records that were furnished to her by the department and apprise the court about the contents of the same. Then, on 23/4, the marks obtained by the candidates were produced before the court, but the court had directed.
It was produced?
Yes. It
on
was
24?
produced. Yes. 23/4.
23/4, okay.
Yes. Then on 5/5/2025, parties are represented by their respective counsels. Ms. Vanessa Milanen government has produced the relevant records as directed by this court. However, since the records are bulky, the learned government advocate shall file an additional affidavit explaining the stages of selection process and the manner in which the determination has been made with reference to the records produced, but without disclosing the marks obtained by individual candidates. The said process is required to be facilitated to facilitate the court to examine the records. In order to prepare and file the additional affidavit, the learned government advocate is given 2 weeks' time. In these records, there is no such handwritten original marks given by the practical test board members. Only the computer type
Let's
marks
see,
were
where is it?
produced.
Additional affidavit filed?
Yes, then additional affidavit was filed and the same was received by the parties.
On 27 June.
Yes.
So where's the marks? Where is it?
Yes, Your Lordship, I have filed on 27 June 2025, additional affidavit.
So here, additional affidavit in compliance with this judgment's order. So now what have you stated
Here
here?
we are explaining the stages of the selection process, which the
Okay.
court has.
Only the stages
Only
of
the
the
stages,
selection
yes.
process. But what about the marks?
In the order, Your Lordship, I am directed not to enclose the mark.
Is it?
Yes, Your Lordship. Without the marks obtained by the participant.
I thought previously the marks were called for. The
Yes.
first order.
Yes, it was called for, and we were looking whether it was tallied or not with the one which the petitioner has submitted. And it was
Shall go
tallied.
through the relevant records that were furnished to her and apprise the court about the contents of the same. Isn't it 2304, contents of the marks? Then, again, the said process is required to facilitate the court to examine the records. So here the next line is, the said process is required to facilitate the court to examine the records. Now, what records is this?
Yes, Your Lordship, in my understanding, what the court wants to know is that whether there is a violation of any rules and procedures. And regarding to that, I have submitted the stages which was followed at the time of assessing this promotion exam. And this promotion exam, the marks are obtaining not only on written, it was in outdoor and indoor facilities.
Okay, wait, then we have to read all the orders together. On
Yes.
12/03/2025, it says, Ms. Vanesiami, learned government advocate, shall produce the official records
Yes.
showing the marks of the petitioners and the private respondents. So what happened to
Exactly.
this?
So I have produced the records, and in that
produced.
records there are different marks regarding the practical and theory, and there is one sheet in which it was written the overall marks, and the overall marks is tallied with the one the petitioner has submitted in his petition, except the one which is not disclosed by way of RTI. So the rest of the marks is tallied.
It's the same.
It's the same.
Okay. Anyway, let's see how. So what do you have to say concerning that?
Yes. In their additional affidavit, Your Lordship, in para 2, see appointment of departmental test boards. A departmental test board was appointed with DGP's approval and subsequently notified by the AIGP headquarters. The board was tasked with assessing candidates and awarding marks for practical outdoor subjects based on their performance. For theory/indoor subjects, written examinations were conducted, evaluated, and scores were compiled along with the outdoor test scores for each candidates. Then assessment of marks by test board. Marks were awarded by the test board members in outdoor and indoor subjects who are reliable and experienced police officers. Video coverage was utilized to ensure transparency and serve a supporting record. Compilation of marks and preparation of result. The score sheet containing the marks scored by the candidates was submitted to the chairman test board on the day of examination itself, and the then marks obtained by each candidate and number of rewards and awards for special courses are also added to the marks and then compiled accordingly and submit to the same to the departmental promotion committee. Here in this para, Your Lordship, it is then after on page number F, the test board submitted the overall result to the departmental promotion committee, and then the departmental promotion committee examined the overall result and then submitted its recommendations to the for promotion to the DGP for approval. Here uh, compilation of marks. The score sheet containing the marks scored by the candidates was submitted to the chairman test board on the day of examination itself. And then the marks obtained by each candidate, a number of rewards and awards, special courses are also added to the marks. Here, the score sheet, which was containing the marks scored by the candidates, which was submitted to the chairman test board, was requested through the RTI, but that original score sheet was not available as per the RTI reply. That is why it is disputed by us. Then there is a contradiction with regard to the affidavit filed by the state. In this, in para 6 of the affidavit in opposition, that with regard to the statements made in para number 16 of the writ petition, I say that the practical test board submitted the computer type marks obtained by the candidates to the department.
Where reading from?
Page number 4 of my petition, of affidavit in opposition. Para
Not the
6.
additional.
Affidavit in opposition.
Wait for some time.
Yes, yes.
Affidavit in opposition by respondents number
Uh,
7
by
to
the state.
21. No,
by the
state.
Yeah, by the state, yes.
Okay, 1 to 6.
Yes. One
This
to
is
six.
dated 18th September.
Yes.
Okay, what happened to this?
In page number 4, para 6, that with regard to the statements made in para number 16 of the writ petition, I say that the practical test board submitted the computer type marks obtained by candidates to the Departmental Promotion Committee, wherein the Departmental Promotion Committee compiled it and prepared the overall result, and then submit the recommendation of selected list for approval to the DGP. Here it is written that the DPC, the Departmental Promotion Committee, compiled it and prepare the overall result. It is the Departmental Promotion Committee who had prepared the overall result. But in their additional affidavit, in para 2E, in page number 4 of the additional affidavit, the score sheet containing the marks obtained by the candidates was submitted to the chairman test board on the day of examination itself. And the marks obtained by each candidate, a number of rewards and awards for special courses are also added to the marks, and then compile accordingly and submit it the same to the Departmental Promotion Committee. Then in the next para, the test board submitted the overall result to the Departmental
Which one are you reading
Promotion
now?
Committee.
The
There is a
additional. You're reading the
Yes.
additional.
Yes, I'm reading the additional affidavit. Page number 4, page para 2EF.
You're just going on submit to see if
Yes.
the court is following you or not, isn't it? You have your case by heart, but you have to tell me what's happening.
Yes.
Which one? What are you reading now?
Page number 4, para 2F, E and F.
What's wrong with this?
Yes. In their affidavit in opposition, the Departmental Promotion Committee had prepared the overall result. But in their additional affidavit, in para 2E and F, in perusal of this para, it is the test board who had prepared the overall result. Here, in para 2E, it is stated that the score sheet containing marks scored by the candidates was submitted to the chairman test board on the day of examination itself. And then the marks obtained by each candidate, a number of rewards and awards for special courses are also added to the marks, and then compiled accordingly and submit the same to the Departmental Promotion Committee. Then in para 2, para F, the test board submitted the overall result to the Departmental Promotion Committee, and then the Departmental Promotion Committee examine the overall result and then submit its recommendation for promotion to the DGP.
Okay, so you're saying that in the affidavit in opposition, test board is not mentioned.
Yes, test board is not. The test board had submitted only computer type marks obtained by the candidates to the Departmental Promotion Committee, wherein the Departmental Promotion Committee compile it and prepare the overall result and submit the recommendation of select list for approval to the DGP. But in their additional affidavit, the Departmental Promotion Committee had examined the overall result, which had already prepared by the practical test board. There is a contradiction with regarding to submissions made through their affidavits also. And moreover, another ground is that two representations were submitted by us. May I kindly bring you to para 15 of my petition. That is on page number 37 of the writ petition.
37.
Yes. The petitioners had earlier, immediately after the respondents number 7 to 24 were promoted to Sub-Inspector of Police, AB, on the recommendation of Departmental Promotion Committee held on 22/2/2024, submitted a request letter for action regarding the unfairness of the said departmental test to the President, Mizoram Armed Police Association, but no positive action has been taken till date. In the said letter of request, the petitioner had brought to the knowledge of the President of MAPA their grievances with regard to the unfairness and injustice committed during the practical test conducted by the Departmental Promotion Committee. For the sake of brevity, the contents of the said letter are not repeated herein and may be read as a part of this petition. That my letter is at Annexure 13.
Okay, this you have already read, isn't
Yes,
it?
yes,
Mafa?
yes.
So what happened? No reply?
And para 5 of their affidavit in opposition. That
This
with
is
regard-
regarding the representations.
Yes. The para 6 of the affidavit in that with regard to the statements made in para number 15 of the writ petition. It is an admitted fact that the General Secretary Mizoram Armed Police MAPA forwarded the request letter of grievances for taking action regarding the alleged unfairness of the departmental test. However, on careful examination of the case, no illegality or unfairness was found against the action taken by the practical test board. It may be submitted that the answering respondents were selected on the basis of performance and merit and as such, oh sorry, this is the incorrect one. May I be allowed to affidavit in opposition on behalf of the state respondents 1 to 6. With para 5, page number 3 of the opposition. Yes. That with regard to the statements made in para number 15 of the writ petition. I say that the General Secretary Mizoram Armed Police Association MAPA forwarded the request letter of grievances, request for taking action regarding the unfairness of the departmental test, claiming that 6 selected candidates are not fit for selection promotion. In pursuance of the said letter, the case was examined carefully, but no unfairness or Injustice was found committed by the practical test board. Therefore, no further action was taken in this regard. Then, in page number 14
Of what?
of the same affidavit in opposition.
14.
Yes, 1-4. That was a forwarding letter of our representation submitted to the MAPA, to the DGP. And the next page is the letter, then the signatures are from page number 17. And on page number 22, it is written that the General Secretary MAPA forwarded an appeal from non-selected candidates of TTP 2024 regarding promotion of SIAB by departmental promotion test conducted during 29 January to 5 February 24 at Third Battalion MAP Parade Ground, Mualpui. The non-selected candidates claim that some of the selected promoted candidates are not fit for selection according to their performances. 139 numbers of Havildars, 5 Nikes, and 8 constables signed their names in the appeal. Then the following selected candidates whose results are not satisfied by the appellants with reasons stated against their names. Number 1 is H. Lalmal Soma, rank position in the test. His performance in command and control and weapons practical was poor. Ramthar Ngaka, he already knew he is selected, but his performance were not at the level for selection. Ratan Mahata, he was house attendant to the then IGP headquarters, chairman of the test, and is known for his incompetence during the exams and practice. Chuman Prasad Ray, his performance in weapons practical was not up to the standard. Vandal Peka, he was about to quit the exam but pushed by his friends, and according to his father, they allegedly provide money to the authorities. Lalming Sanga, his performance inefficiency in drill was not up to the marks. Some of the candidates are seeking information or documentation relevant to their case through RTI, and documents in connection with the examination were produced to the Home Department as demanded. Put up for perusal. Direction, please. Then here it is put for decision, further perusal. It is written, but no response was given to us with regards to this representation. And why we disputed the result is that with the petitioners, these respondents are sitting together or doing together the practicals and indoor and outdoors. Their performance were seen by the directly seen by the petitioners. They were not; these candidates were not expected to be selected while doing their practical exams. But while the result was declared, it is to our surprise that they were selected. That is why a representation was submitted. Then in para 18 of my writ petition, that we have again submitted the representation before approaching this honorable court, that the petitioners had submitted representation dated 3/6/2024 to the respondents number 3, and the same was received by him on 5/6/2024. In the said representation, the petitioner stated that the video footage in connection with practical test for promotion of Havildar to inspector held at MAP Parade Ground during 29 January to 5 February 2024 was recorded. For the sake of their fair selection and for the end of justice, they requested the respondent number 3 to issue direction for review of the said recorded video footage along with all the original marks secured by the participants during the practical and written test conducted during the aforesaid departmental test and make reassessment again for selection. Video footages of 15 Havildars who had already been promoted to SIAB, whose results disputed to the petitioners are enclosed along with the said representation for review and for making reassessment of their performances during the practical test. By the said representation, the petitioners had most respectfully prayed and benign authority to the respondent number 3 be pleased to review the notification dated 6/11/2023, notification 5/12/2023, and the overall result of the departmental test for Havildar for promotion to the rank of Sub-Inspector Police AB and office order number dated 29/2/2024, and further be pleased to modify it to the extent of setting aside the order, thereby issue a direction to fill up those vacancies as per the provision of Mizoram Police Manual 2005 and afford opportunity to them, together with any other eligible Havildars. That is our representation. Since there is a video footage, video recording of the practical test conducted during the departmental test, so we request the higher authority to review those videos and make reassessment. But it is also not, no action was taken with regard to our representation. Then that is why we came before this honorable court. So then in para 17 of my writ petition, that I have mentioned that the video footage is in connection with practical test for promotion of Havildar to Sub-Inspector held at 3rd Battalion MAP ground was recorded. The said video coverage was obtained by P.R. Lalmun Moi, resident of Tifa with Aizo through RTI application 7/3/2024. The said video footage was also provided to us through RTI.
So it was provided to you?
Yes. In Annex 15 of my writ petition, that is on page number 88 and 89 of my writ petition, that RTI reply was annexed. In page number 89 of my writ petition,
Yes.
Annex 15A, response to inquiry made to RTI Act 2005. The answer to the information you have seek to RTI dated 7/3/2024 regarding Havildar to ABSI DPE practical test video coverage was furnished using your external hard disk. It was provided to us through our external hard disk. And in their additional affidavit also, they have stated that a video coverage was done. In additional affidavit of the state, page number 3, para to the marks were awarded by the test board members in outdoor and indoor subjects who are reliable and experienced police officers. Video coverage was utilized to ensure the transparency and serve as a supporting record. That was also mentioned. Then we have already asked to review those videos, but no reply was given to us with regard to our request. Then in affidavit in opposition on behalf of the state, para 8 also stated that
Affidavit in opposition,
Yes, affidavit in opposition.
para 8.
Para 8, page
What do they
number
say?
4, yes. That with regard to the statements made in para number 18 of the writ petition, I say that all the members of practical test boards are reliable officers. Therefore, the overall marks by practical test board members are accepted by the competent authority, and a video coverage was used as one of the documents in departmental test. The departmental promotion was constituted as per that. What I like to mention is video coverage was used as one of the documents in departmental test. But this video, there is a video footage, recording with regard to the departmental test, with regard to the outdoor items. But we have kindly request the authorities to review this video coverage, but no such action for review of the video coverage was not taken by the state. Then, with regard to, I like to mention also another ground, the third ground for my challenge is with regard to the appointment of practical test board. Para 21 and 22 of my writ petition.
Writ petition.
Yes.
Yes, what does it say? Para 1 and 20, 21 and
21,
22.
yes. That as per the standing order number dated 22/11/2021, the test will be conducted by the test board appointed by the DGP, which will make objective assessment of the candidates based on their performance in the test and submit list to the DGP for consideration of promotion in order of merit by the DPC duly constituted by the Government of Mizoram via number dated 7/7/2020. It is pertinent to mention here that on careful perusal of notification number 5/12/2023, by which practical test board was constituted, the practical test board was not appointed by the DGP in gross violation of the standing order dated 22/11/2021. In para 22, the above said arbitrary manner by which two officers of the rank of commandants were included as member of departmental promotion committee, and the casual manner by which practical test board was appointed had been overriding the provisions of the Mizoram Police Manual 2005 and was a total deviation from the standing order. The procedure adopted by which departmental promotion committee practical test board were totally illegal, and the promotion of those havildars cannot be legalized in violation of the rules and orders. Here, what I'd like to mention is in para 11 and 12 of the affidavit in opposition on behalf of the state respondents.
Yes.
Yes. In page number 6 of the affidavit in opposition, that with regard to the statement made in para number 21 of the writ petition, I say that the appointment of departmental test board for promotion of havildar to ABSI was duly constituted as point number 8 of standing order dated 22/11/2021, and with the approval of the DGP Mizoram, and then notified by the AIG headquarters. Therefore, no question of violation of standing order arise. In page number 27 of the same affidavit, here in the handwritten of that note sheet in the last para, as discussed today, proceedings for promotion of havildar to SIAB is initiated. However, ECI clearance may be sought. Meantime, procedure and test board is prepared as per Mizoram Police Manual 2005 and put up for approval.
So
It
what's
is-
wrong?
What is wrong is that it is written that the practical test board is prepared as per Mizoram Police Manual 2005. But there is no provision for such preparation of uh, departmental test board in the Mizoram Police Manual. In the next page, there is a standing order, page number 29 of the same affidavit in opposition. Page number 28 is the standing order. Then point number 8, the test will be conducted by the test board appointed by the DGP, which will make objective assessment of all the candidates based on their performance in the test and submit list to the DGP for consideration of promotion in order of merit. It is the standing order which had allowed the respondents to form practical test board. The police manual is at page number 23 of the same affidavit. A copy of the Mizoram Police Manual. Then in page number 24, standing order, police manual, rule number 397, promotion to the rank of sub-inspector, that is written. In those rules, under 397 or 396, there is no provision for appointment of departmental test board. So,
This eligibility, isn't it?
yes,
Eligibility, 5 years, they're all eligible, then what pay?
method of selection. Then, what I like to mention is that Mizoram Police Manual that does not provide for the appointment of practical test board. It is the standing order which
So it's noting some mistake can be made, just a noting, the officer may not know, but how was it actually done? That we have to see, no?
yes. Then the practical test board was appointed.
So many mistakes in the notings.
Yes.
These are just notings. Sometimes they just write rubbish also.
Then on page number 51 of my writ petition, that is notification for appointment of practical test board.
51.
Yes,
Notification.
yes.
Yes.
It is the Assistant Inspector General of Police Headquarters. who
So
ha-
this is correct? Page number 51 is correct or wrong?
it is wrong because
Okay, why?
the standing order had provided that it is the DGP who is to appoint the departmental test board.
Okay, and you're saying it's appointed by the assistant.
Inspector
IGP.
General of Police Headquarters, yes.
Okay.
And my last submission, Your Lordship, on page number 23 and 24 of my writ petition. Oh, sorry,
Yes.
para 23 and 25. On page, para 23, page number 44 of my writ petition, that as per Rule 397 2F, a selection list shall be drawn up by the committee and submit it to the Director General of Police for his approval. Rule 3972G of the Mizoram Police Manual 2005 further provided that the Director General of Police, after approval, shall send the names in order of grading to the
Wait,
units.
we're reading from para
Para 23,
23.
yes.
That as per,
Yes,
okay.
page number 44. That as per Rule 3972F, a selection list shall be drawn up by the committee and submit it to the Director General of Police for his approval. Rule 3972G of the Mizoram Police Manual 2005 further provided that the Director General of Police, after approval, shall send the names.
Okay, where are those rules? You have them?
Yes, I have in page number 940 of my writ petition, I have reproduced the rules.
No, give me those rules. You can write anything here. You see, for those, you just get a Xerox copy of the relevant portion with the first few pages so that we'll know it's this rule.
It is also annexed in the
It's
affidavit
annexed?
in opposition of the state, page number 23.
So read from here.
Yes. Rule 397. In Rule 2F, page number 25. A selection list shall be drawn up by the committee and submit it to the Director General of Police for his approval. The Director General of Police, after approval, shall send the names in order of grading to the units where vacancies exist, and the Commandant will promote them. It is the Commandant who is to promote those selected lists. But on perusal of the promotion order, on page number 72, office order dated 29/2/2024 in my writ petition. It is not the commandant's, it is the, on page number 73, Assistant Inspector General of Police Headquarters had promoted those 18 selected candidates. It is a violation of the rules. With regard to this, I would like to submit one decision of the Apex Court.
Para?
In para number 15, page number 5.
Oh, give the citation anyway. This is?
Yes. Supreme Court of India Division Bench, 2015, volume 13, SCC, page 722, 722, yes.
Para?
Para number 15. Where the law prescribes a thing to be done in a particular manner, following a particular procedure, it shall be done in the same manner, following the provision of law, without deviating from the prescribed procedure. That is my submission with regard to the violation of these rules. Then, to conclude my submission, we have already submitted 2 representations with regard to the instant case, but no such action was taken in our favor. Then we are approaching this honorable court. Then we ask this honorable court to give us a chance to be considered again for promotion to the SI arm branch from the Havildar, because there is unfairness with regard to the marks given, overall result, preparation of overall result, because no such original marks given by the practical test board members were not available while preparing the overall test result, because only the computer type marks were submitted. And also there is also already a video coverage which is already available, the record kept by the police headquarters. Then by reviewing this video coverage, reassessment can also be made with regard to the overall result. Therefore, we
Okay.
yes, that's all my submissions.
Yes.
Yes, Your Lordship. May it please Your Lordship. First, let me rebut the submission which with the petitioner counsel had mentioned regarding the RTI, Your Lordship. That is clearly explained in my affidavit. That is in page number 2, para number 4.
Para 4.
Yes, Your Lordship. Here it is clearly mentioned that the reason why their marks
Yes.
were not given to them because consent has to be taken as per Section 11 of the Right to Information Act 2005. So, without their consent, the department cannot disclose their marks. So the reason has well explained why this is not disclosed, and there is no unfairness means regarding regarding that marks were not disclosed to them. Even the petitioner claims that there is unfairness and refused to disclose the marks. But the reason why the marks were not disclosed is that as per the rules and act of the Information Act. So there is no unfairness regarding this. And with regard to the submission made by the petitioner that the DGP has made the appointment. In that regard, Your Lordship, what I would like to mention is that I have explained in my affidavit, page number 7, that is in para 13.
Para 13.
Para 13, Your Lordship. If I may read out. That with regard to the statement made in paragraph number 23 of the writ petition, I say that the names of selected candidates are, as per recommendation of Departmental Promotion Committee, was sent to DGP for approval, and promotion order are arranged in order of merit, which was approved by DGP as per Rule 3972G of the Police Manual. Promotion order are to be issued by the commandants. However, this provision is impracticable since the inter-se seniority of sub-inspector are maintained at the police headquarters. If the commandants issued order of promotion by their own separately, it causes problem in regard to order of merit, which will affect their seniority. As such, the matter of proceeding is centralized at police headquarters in the interest of their service matters. Therefore, the order of promotion was issued by the AIG headquarters, as the AIG headquarters is an equivalent rank of commandant who is also appointing authority and is authorized to issue the instant promotion order. Centralization for issue of orders for promotion and transfer and posting has been practiced since long time in order to maintain service matters and seniority properly and correctly, as well as for the betterment of the department and for the interests of police personnel as well. Therefore, this does not violate Rule 3972G of the Mizoram Police Manual 2005. And Your Lordship, regarding the minor discrepancies in the sentence and all, that what the department means to say is all the same, only the wordings are not the same. It says that the test board compiled the marks and sent to DPC, and the DPC re-examined the overall marks and submitted for promotion. So there is no discrepancies regarding that one. What we have to look is that whether there is a violation of rules for the promotion, and the petitioner fails to point out the rules which violates for the promotion of that one. And the standing order is fully compiled. And my lord, what I would like to mention here is that there is different subject, various subject regarding to the test. And the petitioner has mentioned in their representation, some of them have mentioned about the drill, only one subject each. But what we have to see is that the overall test has to be compiled. And not only that, Your Lordship, there is also another thing which is added into their marks. Your Lordship, if I may take it to the standing order, which is annexed in my affidavit, page number 28. Page number 28.
28,
28.
yes.
In point number 2, the first test has to be medical examination. Medical examination, and point number 3, there are another points which is listed out in number 1, personal turnout, proficiency in drill, command and control, weapon, theory and practical, field craft and map reading. And not only this, Your Lordship, in the bottom below there is another thing, rewards. 1 mark for each reward, maximum 5 marks. Punishment, 1 mark to be deducted for each minor punishment, maximum 5 marks. And there are another bonus marks. So, Your Lordship, there are different categories of marks which have to compile together. And you cannot say that only in the practical that he is not efficient in that practical things. That cannot fail, or that cannot differentiate
So
the mark,
there,
because the
this
over
thing
marks
is-
have to look into.
Their point is that weapons, isn't it, controlling of guns, theory and practical?
We cannot say that
I think that is their point.
in
Something
the
to do with the
representation they
weapons.
did not mention clearly, only the video footage, and they did not mention what footage was that. Only the video footage is there. And in that footage, what has been shown or what have been conducted cannot be known by us, because they cannot
Cannot
made
be
it
the
specifically.
sole grounds. Okay,
Yes,
fine.
Your Lordship. And as already stated before, Your Lordship, all the marks for the indoor and outdoor were compiled, and even in that marks, if they got the reward, even that one is also added. So selection was based on merit cum suitability of the candidates. And the petitioner has failed to mention the grounds which have been made. And regarding the video footage, Your Lordship, what I would like to mention is that if he has to raise that footage, it has to be looked into by way of evidence. And at this time, what we have to see is that whether there is a violation, and the petitioner did not disclose any violation of rules. And Your Lordship, in this regard, I would like to rely
Yes.
on
The
some
majority.
citation. 2014 14 SCC 370.
2014, 14 SCC 301,
370.
370.
Para 11.
Yes.
It is settled that the High Court under Article 226 of the Constitution of India cannot sit in appeal over the assessment made by the DPC. If the assessment made by the DPC is perverse or is not based on record, or proper record has not been considered by the DPC, it is always open to the High Court under Article 226 of the Constitution to remit the matter back to the DPC for recommendation, but the High Court cannot assess the merit on its own on perusal of the service record of one or the other employee. And in Para 13, the bias and malefice act can be adjudged only on the basis of evidence. The assessment of character role by one or the other officer giving a general grade such as good cannot be the sole ground to hold that the officer was biased against the person whose character role is assessed. In the instant case, there is nothing on record to suggest that appellant 3 E.N. Ram Mohan was biased against the respondent merely because he assessed the SCR of the respondent as good as against assessment of very good made by IO. It cannot be said that he was biased against the respondent. And in Para 4, Your Lordship, The departmental promotion committee consists of a chairman and the members. Even if bias is alleged against the chairperson, it cannot be presumed that all the members of the committee were biased. No grounds has been made out by the respondent to show as to why the assessment made by the DPC is not to be accepted. The High Court failed to notice the aforesaid facts and wrongly discarded the assessment made by the DPC. And another citation, Your Lordship, 2018 15 SCC 796. Para 17. The selection committee consists of experts in the field. It is presided over by the chairman or a member of UPSC and is duly represented by the officers of the central government and the state government who have expertise in the matter. In our considered opinion, when a high-level committee or an expert body has considered the merits of each of the candidates, assessed the grading and considered their cases for promotion, it is not open to CAT and the High Court to sit over the assessment made by the selection committee as an appellate authority. The question as to how the categories are assessed in light of the relevant records and as to what norms apply in making the assessment is exclusively to be determined by the selection committee. Since the jurisdiction to make selection as per law is vested in the selection committee, and as the selection committee members have got expertise in the matter, it is not open for the courts generally to interfere in such matters except in cases where the process of assessment is vitiated either on the grounds of bias, malafide, or arbitrariness. It is not the function of the court to hear the matter before it, treating them as appeals over the decision of the selection committee, and to scrutinize the relative merits of the candidates. The question as to whether a candidate is fit for a particular post or not has to be decided by the duly constituted expert body, that is, the selection committee. The courts have very limited scope of judicial review in such matter. And in para number 20. This court has repeatedly observed and concluded that the recommendation of the selection committee cannot be challenged except on the ground of malafide or serious violation of the statutory rules. The courts cannot sit as an appellate authority or an umpire to examine the recommendations of the selection committee like a court of appeal. This discretion has been given to the selected committee only, and the courts rarely sit as a court of appeal to examine the selection of a candidate, nor is it the business of the court to examine each candidate and record its opinion, since the selection committee constituted by the UPSC is manned by experts in the field. We have to trust their assessment unless it is actuated with malice or bridles with malafide or arbitrariness. And Your Lordship, another citation, the last citation. 2021 8 SCC 784.
8 SCC.
8 SCC 784. Para 43.
Yes.
The power of judicial review over the administrative decision of the state was examined by a judgment of this court in Tata so and so. Though that is a case of a grant of contract, but the principle of law are very well applicable to the exercise of power of judicial review by the High Court. In the administrative decision of the state within the meaning of Article 12 of the Constitution, the court held as under. The duty of the court is to confine itself to the question of legality. Its concerns should be, number one, whether a decision-making authority exceeded its powers. Number two, committed an error of law. Number 3, committed a breach of the rules of natural justice. Number 4, reached a decision which no reasonable tribunal would have reached. Or number 5, abused its powers. Therefore, it is not for the court to determine whether a particular policy or particular decision taken in the fulfillment of that policy is fair. It is only concerned with the manner in which those decisions have been taken. The extent of the duty to act fairly will vary from case to case. And, Your Lordship, in para 46, sub para 28. In any case, the High Court exercises its extraordinary jurisdiction under Article 226 of the Constitution of India to enforce a fundamental rights or some other legal rights or the performance of some legal duty. To pass order in a writ petition, the High Court would necessarily have to address to itself the question of whether there has been breach of any fundamental or legal rights of the petitioner, or whether there has been lapse in performance by the respondents of a legal duty. The High Court, in exercise of its power to issue writs, directions or orders to any persons or authority to correct quasi-judicial or even administrative decision for the enforcement of a fundamental or legal rights, is obliged to prevent abuse of power and neglect of duty by public authorities. In exercise of its power of judicial review, the court is to see whether the decision impugned is vitiated by an apparent error of law. The test to determine whether a decision is vitiated by error apparent on the face of the record is whether the error is self-evident on the face of the record, or whether the error requires examination or arguments to establish it. If an error has to be established by a process of reasoning on points where there may reasonably be two opinions, it cannot be said to be an error on the face of the record and held by this court. So I will jump to sub-para 31, Your Lordship. The sweep of power under Article 226 may be wide enough to crush unreasonable orders if a decision is so arbitrary and capricious that no reasonable person could have ever arrived at it. The same is liable to struck down by a writ court. If the decision cannot rationally be supported by the material on records, the same may be regarded as perverse.
Okay.
So, Your Lordship, to conclude my submission, the petitioner did not disclose what laws has been violated for the promotion.
Yes.
So, regarding to the judgment which I have cited, Your Lordship, I pray to dismiss this petition, writ petition.
Yes.
Okay, please, Your Lordship.
Private respondents. How many private respondents?
18, my lord. 18 private respondents are here.
Hmm.
Now, my lord, since the day we were promoted on 29 to 24, we have joined the post of SI for about 1 year and 5 months, excluding this
Date
month,
of promotion?
29 to 2024. Now we are spending now 1 year 5 months as SI. Now we are asking ourselves, it would be more unfair if this promotion order issued to us is quashed or set aside. Well, that is my first point. Now, Your Lordship will see that we were selected based on merit and overall performance, according to the criteria laid down in the practical test board. Now, my learned friend has imputed allegation of unfairness with regard to the DPC or the practical test board. But surprisingly, my learned friend for the opposite party has not challenged the constitution of the DPC and the practical test board. He has only challenged our promotion order, and that has not been stayed till date. Now, my learned friend has also submitted that due to non-submission of the original table marks, that the selection was unfair. Now here, my learned friend has submitted malified or bias in the selection process, but that malified has not been established prima facie. My learned friend has mentioned the video footage of the practical test board, which he has stated that he has submitted along with the representation. But that is not with the purview of this honorable court to assess that, that in my humble opinion, my lord. Now, with regard to the original table mark not being submitted, my lord, I would like to submit the judgment of the Honorable Supreme Court, rendered by two judgments. This judgment of the Honorable Supreme Court is against the decision of the High Court of Jammu and Kashmir. 3. It's a two judgments. Tasvir Singh Sodhi and others versus the state of Jammu and Kashmir. My lord, also, may I start from para 14, page 21. It's paginated at the bottom of the page.
Yes,
I think this will squarely cover our case. With your lordship permission.
yes.
In the present case, the entire selection of the appellants has been caused by the High Court primarily on the ground of non-availability of individual award rolls or mark sheet. Awarding marks individually, whether such an irregularity would vitiate the entire selection process and set it at naught, is the next aspect of the matter that requires consideration. The decision of a three judge bench of this court in so and so involved recruitment to various posts in the educational services of the state of Uttar Pradesh. There was a two-stage recruitment involving a written test and an interview therein. It was found that after the written examination, due to the improper feeding of data into the computer, some candidates who had a better performance in the written examination were not called for interview, and candidates who secured lesser marks were not only called for the interview, but were finally selected. The entire process was cancelled by the PSC, Public Service Commission. In the said context, this court observed as under. We have heard so and so. I'll just keep this, my lord. I'll just turn to the next page. No, my lord, I'll start from the aforesaid case, the last para. The aforesaid case is therefore representative of a situation where the cancellation of the entire recruitment process was held to be not justified, since there was no systemic flaw in the written test and the issue was only with regard to award of marks to the candidates in the interview. The situation could have been remedied by setting aside the selection made after the interview stage and calling for a fresh interview of all eligible candidates if the case so warrant, which is also not so in the instant case. I'll straight away jump to page 24. Page 24, para F. Para F. Select list was prepared on the basis of total marks allocated for academic qualification as well as marks secured in the interview. In the light of the pertinent selection procedure that was followed, we are unable to hold that the same was mechanical or casual or suffer from irregularities which were so grave or arbitrary in nature so as to justify causing the entire selection process. Further, we are unable to trace the requirement of individual roles being signed and verified by the members of the selection board to any statute or rule. Therefore, we cannot sustain the finding of the High Court that the entire selection process was vitiated by such irregularity. The High Court was not justified in causing and setting aside the entire selection process, more so when 64 candidates, including the appellants, had been serving on the said post for over a decade. Reliance in this regard may be placed on next page, Manoj. Trivedi Himanshu Ghanshyambai, wherein it was held that merely because the records could not be produced since they were lost and not available, the appointment could not be cancelled. Now, the case of my learned friend is that the original table marks was not furnished some of the selected candidates. Now herein the Honorable Supreme Court has held that even if the records could not be produced, whether they were lost or not available, the appointment could not be cancelled. So, coming back to our case, there is no rules in the Mizoram Police Manual which mandates that the original marks allotted to the candidate has to be retained. There is the moot question, my lord. So my learned friend has submitted that some of the marks which were given to the petitioners were not given to them through the RTI. But the fact of the matter is that we had secured more marks and our performance is better, and that is the reason that we have been selected. Your Lordship will see that at page 74 of the writ petition, the names of the petitioners, the respondents, private respondents, are mentioned above all the petitioners. So which clearly shows that we are more fit to be promoted to SI from Havildar.
Okay, so up to serial number 18, they're
18.
promoted.
Now,
So here, out of this, 1, 2, 3, 4, 5, 6, 7, 7 of them are not willing to disclose your marks.
Yes. And
Okay.
that does not go to the root of the matter, or there cannot be it cannot be inferred that the selection process is biased or arbitrary.
Okay.
Now, the marks is also produced by my learned friend for the government before this honorable court. Another submission, my lord, is that since the petitioners has taken part in the selection process, knowing fully well the composition of DPC and the practical test board, including the criteria for assessment, they cannot now turn around and say that this is not correct, that DPC is not correct or the practical test board is not
No,
correct.
composition of GPC,
They have not challenged. They have not challenged, but they have made a mere vague statement that it is unfair. That is why. So, since they did not fare better than us, they cannot challenge our appointment because we were selected based on merit.
okay, what about the rules?
Now,
It says appointment has to be
Yes,
made
yes,
by
yes.
the commander. Can you distinct that?
Since
Who has made the appointment?
DPC, the selection has to be done by the DPC.
Oh.
Now,
Let's come back to the rules. Wait, where are we?
397.
397.
397 sub clause 2, method of selection.
Yes.
Since my learned friend,
Method of selection.
yeah, since my learned friend for the government had already apprised this court, but I'll just read this one for my benefit. Promotion shall be on selection. That is not disputed. The process of selection shall be done by the departmental promotion committee consisting of the IGP as chairman.
So DPC is not challenged, so leave
Not
that.
challenged. Yes, yes. Now, what my learned friend submits,
F and G.
G. Here, according to our interpretation, here the promotion shall be done by, or the selection shall be done by DPC. Promotion means it's only ceremonial because the commandant and AIGP, their rank are the same. As my
rank
learned
is
friend has
same.
already, yes.
So, but it's all been approved by the DGP, isn't it?
Yes, yes, yes.
Approval of DGP is taken?
Yes, madam. It's more or less trivial in nature what my learned friend has submitted, that the commandant himself will promote all the promotees. According to us, it's only directory because the wording, according to us, is not mandatory. It simply says will, and that means it's only ceremonial because they were already selected by the departmental promotion committee. And the allegations made by my learned friend for the petitioner that the DGP did not accord his approval. They have failed to produce any evidence before this honorable court And the burden of proof lies on them, Madam. Everything.
This DGP's approval,
Yes, Madam.
not approved.
That is their submission. But they have to show that